Okay, welcome back, folks, to House Human Services. We are continuing our discussion about H92, which is an act relating to changes in the Human Services Board. And this morning, we are hearing from family members of individuals who have been through the process. And we appreciate you both being here this morning. We will do a brief round of introductions around the room so that you can. It's hard to see us because I know that we're not that big probably on your computer screen. No. So at least you will know our voices and our names and where we are from. So my name is Teresa Wood, and I am from Waterbury, and I also serve Bolton, Buellscore, and Huntington.
Ann Donahue from Northfield and also represent Berlin.
Hi, good morning. I'm Dan Noyes. I represent Woolgate, Hyde Park, Johnson, and Belvedere.
Brenda Steady, East Milton, Westford.
Hi, I'm Doug Bishop, and I represent parts of Colchester.
Hi, Todd Nielsen, represent Brandon Forestdale.
Good morning. My name is Zahn Eastis. I live in Guilford, and I also serve in Vernon.
Hi, I'm Jubilee McGill from Bridgeport, and I also represent Middlebury, New Haven, and Weybridge.
Hello, welcome. I'm Ray Garofano, and I represent Essex and Essex Junction.
Hi, I'm Lori, the committee assistant.
Joe?
Hi, I'm Joe Randall from the Human Services Board. You might not be able to see me very well. Here in the front.
And Representative Cole.
Hello, Rep. Cole of Hartford.
And welcome, Mr. and Mrs. LaCroix. Very glad to have you here this morning. And you just want to introduce yourselves, and really the floor is yours. We do have a statement from them on our website. And we just are interested in hearing your story and experiences with the Human Services Board. So we really appreciate you being here and are happy to have you.
Thank you. Thank you very much for allowing us to say how we feel. So I am going to be reading off some piece of paper because I'm very nervous. This is not my forte. However, I do believe you guys all have a copy of it. It was sent to Lori Morse.
Yes.
So if I could just, start reading, would that be okay?
That's absolutely fine. And what I'm going to ask committee members to do is to hold any questions that you have until the end. That would be great, until they're done speaking. Thank you.
Thank you. So hello and thank you again. My name is Nancy LaCroix, my husband David LaCroix. I live in Barry where our son receives services under his home and community-based service waiver. We built an accessory dwelling unit on our home for our son to age in place. Our son has autism, and we are his legal guardians, as he cannot assess risk nor consent to his own contracts. We are here to share our experience with the Fair Hearing Board for your bill H92. We have been advocating on behalf of our son to receive care from his agency in his home for the last 5 years. Our son has been denied these services from his agency, from Dale, then again from the hearing officer at the Human Service Board. We cannot appeal our son's case to the Supreme Court, as there is a rule that no evidence can be submitted once the Human Service Board denies your case. Regarding number 1 of your bill, this is our experience. Our son's advocate was stopped from speaking multiple times. She was told she was not properly asking questions. For several hours, we heard, denied, and overruled. Neither of the 2 attorneys gave her leniency for not being an attorney herself. She was speaking our son's voice, and his voice was being denied. Our son's advocate and I worked for months to prepare for the hearing. None of our evidence was allowed into record. We had asked for an accommodation on our son's behalf in the shared living provider contract and submitted clinical records to back up our claim. When we were allowed to speak, we were able to say a few things, but it didn't matter, as all evidence was denied into record. Only facts matter, and the facts were not allowed in. When the final decision came back, our son's case was denied due to lack of evidence. I'll repeat, all evidence was denied into record, and our case was denied for lack of evidence. Regarding number 2 of your bill, reframing from legal ease, the 2 attorneys denied every piece of evidence and blocked most questions. So we were blocked from proving our case. If our case had merit, these 2 attorneys blocked it from being heard. Is their job to determine legal merit or block justice? It was a day that haunts us and continues to haunt us. We feel Dale Attorney and the Fair Hearing Attorney violated our son's First Amendment rights to put evidence into record and his 14th Amendment right to due process. The fair hearing process appears to be an avenue to block justice and an unconscionable waste of taxpayer dollars. We were at the hearing because our son was given an adverse benefit letter denying him staffed home and told that shared living was adequate and most cost effective. Yet Vermont's H171 vulnerable adult law defines our son as a vulnerable adult, regardless of residence. Shared living is not required to be licensed, leaving our son without a way to mitigate risk as he cannot report abuse. Again, my husband and I are his legal guardians, as we cannot mitigate risk, as he cannot mitigate risk. This appears to be a bad faith contract, and we were seeking a good faith contract. Our son's agency has given him a take it or leave it situation, take unlicensed care, even though it is contrary to Vermont H171 law. The contract in question is a contract that legal guardians cannot sign or see. So we have no way of mitigating the risk on our son's behalf prior to consenting to this contract for our vulnerable adult. I respectfully request that the Human Services Committee investigate this injustice because our family is being harmed. I had questioned the ex-Deputy Commissioner of Dale if she was the authority who regulates the contract. And the reply I received was, we require a contract, but we do not regulate it. If Dale does not regulate the contract, then it would make sense that the Human Service Board does, as that was the next step in our grievance. If the Human Service Board had the subject matter jurisdiction to approve or deny any type of accommodations in the contract in question, then our evidence would have been accepted, then confirmed or denied based on the allegations of the contract. Our son's case was not dismissed for jurisdictional reasons. His voice was never heard at all. Subject matter jurisdiction is the power of a court to adjudicate a particular matter and provide the remedy demanded. Where is the state entity that has authority to hear our case if it is not the Human Service Board? Then who? We have never felt more dehumanized, exhausted, and gutted by this whole unfair process. And my husband and I are still feeling the effects of it. We appreciate you taking and hearing our testimony today. Thank you.
Thank you very much. I'm just checking in with Mr. LaCroix to see if he has anything he'd like to say.
No, ma'am, I helped my wife write it, and I felt that she was more astute at saying it than I was. Thank you.
Okay, well, you know, we all have different strengths, right?
So true.
Yeah, so thank you both for being here. I'm going to open it up to the committee, and I do want you to know that we've been joined by Representative McFawn. I know you know him well. And he is the sponsor of the bill. He sits on the Healthcare Committee, but has joined us for your testimony.
Thank you.
And we also have some students here who are visiting the State House. They just arrived in the room and are learning about how laws are passed and what happens in the State House. So welcome to you all. Where are you from? Hartford. Oh, okay. There we go. Representative Cole is one of your representatives. So, okay. Thank you. Go ahead, Representative Garofano.
Thank you so much for sharing your experience. It is so helpful for us to hear, from your perspective, what this process is like as we kind of embark on improving it for others. Can you talk a little bit about how long this whole process took, how many hearings you had to go through approximately? I know I've heard from Representative Fawn that it was really lengthy and.
Well, we started, we've been to the Human Service Board twice. But if you're looking all in all, we started advocating for our son in 2019. The agency received our son's clinical assessment, and we started talking to our agency in January of 2020. So it's been this long for us to receive ethical health care for a long term in our son's own home that he will own.
Thank you.
Go ahead, Representative Bishop.
I echo the appreciation for you spending time with us today to share your experience. I'm curious if you could share a little bit more with us about, as you reach different stages of the process, what information you may have received in advance of that stage and how you felt it did or did not illuminate what you were about to step into.
Well, I think there was a guidebook on the process. But you need to appreciate that, we are laymen, we are not lawyers. And we thought that we could go before this board and not need to have an official attorney with us to represent, nor did we believe that the evidence that needed to be put into record to support what we were requesting was going to be denied. That on its face, when you look at Dave and I speaking for our son with autism, who can't speak for himself, his voice was completely unheard. And there was no leniency, in our opinion, for the fact that we are lay people, okay? We're lay people. And on its face, to deny pertinent documentation that would help anybody understand the merit of the case, and that the subject matters and the shared living contract was denied into evidence. Even my son's clinical record was denied into record. Well, how can you adjudicate anything if you can't have the contract in question and the clinical record submitted into record? So it's a very sad situation.
Yeah, it's a lot of time preparing for all these meetings. It's if we weren't retired, there was no way we could do it if we were working. I mean, you're talking, couple days, 3 days preparation, with our advocate for every meeting, and it consumes your life. It's totally intense. And I mean, I don't know the number of meetings we've been through, but I'll guarantee you that it's a pretty good number.
Let's just say that we are not the same people we were 5 years ago. Not in any stretch of the imagination are we the same people.
I can feel the stress in your voice and
we're not the same, because no human being should have to go through this amount of work to get what is needed based on documentation. The sleepless nights, the stress, the worrying about your son and what will come of him when you pass away is unconscionable behavior. Unconscionable.
Did you understand when you decided to make a decision to appeal to the Human Services Board that it was, I guess what I'll call a quasi judicial setting, you know, that there would be people objecting and all of that kind of stuff. Was that process ever really explained to you?
Not in detail. We thought that we could go and again, we understand that there has to be some rules and decorum and all that kind of stuff in a process. I understand that. But when you know, my son's voice was trying to submit his own medical record and that wasn't accepted, that goes below the belt. It's below the belt when you're dealing with with people who are lay people. Okay. And it just shouldn't happen. It should not happen. And to presume that families can go through this process and liquidate all of their assets to fight something that at the end of the day doesn't allow the record in question to be put into record. I mean, this is a no-win situation for not just us, but across the state.
Did you, I'm wondering if you expected to be able to at least say your story, you know, and share your information. And of course, the department may or may not have agreed with it, and then they would say their side of the story. And it sounds like that sort of give and take wasn't allowed in your circumstance, that each time you tried to present something, there was an objection, so it was never actually heard.
Well, so here's the thing. We weren't going there so that we could just be in therapy and just air out our stuff, okay? This was about getting accomplished an adjudication for the in question to a contract that my son is being offered. So I didn't need a therapy session. I needed to get a result, okay?
Right.
And you can't get a result when the state's own contract in question and my son's clinical records and the law are not allowed into record. When those things aren't allowed into record, of course, everybody's going to fail.
Representative Eastis.
Yes, thank you so much for sharing your story. You mentioned earlier an advocate that you were working with. I wondered about did you have any kind of relationship with legal aid, Vermont Legal Aid, or anything like that as you were moving forward?
In the process, we have gone to legal aid before and they could not help us.
No, we were denied there. That was absurd. They wouldn't even help us a bit. No.
Can you explain a bit more why, what they told you?
You know what? It's been 5 years and I'm going to be quite honest. A lot of this is a blur to save my sanity. So to ask specific questions on that, I cannot recall at the moment.
Fine, thank you.
Of course, they're understaffed. That doesn't help. So they're always overloaded with cases also. So
Just fine. Thank you.
Thank you. Other questions from committee members? Okay. Is there any, final thoughts that you want to leave us with? Because it looks like the questions have been exhaustive for now.
What we want is for the resolution of the Human Service Board to decide what is their jurisdiction. If they never had the jurisdiction to accommodate the shared living contract, then we were brought through a Ferris wheel of spending time doing nothing. The state of Vermont needs to find an entity, again, where I said, where is the state entity that has the authority to accommodate a one-size-fits-all shared living contract for somebody who's an involuntary ward who owns his own home. And my son has the right to be left property, own it, and pay his taxes and live there with dignity and respect and privacy.
So that just led me to another question. Sorry. So you were asking were you asking the Human Services Board for a ruling about things that you found as your son's guardian objectionable in the contract, the shared living contract that is between the designated or specialized service agency and the provider? Is that what you were asking for them to have some sort of ruling about that?
we're asking for an accommodation, an ADA accommodation in the shared living provider contract because it is not seen by the legal guardian. My son cannot mitigate his risk. He cannot decide if this contract and the way it's written is going to be healthy for him lifelong. It is the legal guardian's responsibility to make sure that whatever contract my son's name is attached to, that it mitigates his risk and it keeps him safe per his clinical records and his person-centered plan. A legal guardian is not allowed to see this shared living contract. And that's unconscionable. It's unconscionable when you have somebody who doesn't know how to mitigate their own risk.
Okay, I'm understanding I'm understanding better what your issue was.
Yeah.
You know, that you brought to the board, which might have been helpful if you knew at the beginning that that was, I don't know what the exact decision was, so, but I know that that contract is between the agency and a third party. So I can imagine what the ruling was. Okay, are there other, yeah, Representative McFawn?
I think they can tell me what the ruling was.
Well, I mean,
know what it was.
They did, right?
Yeah.
I think that they said that it was denied. I don't know the specifics
lack
of
of
it.
evidence.
For lack of evidence, yeah. That was the reason that was given, for lack of evidence or
Yes.
jurisdiction. There wasn't anything about jurisdiction?
No. It was denied based of lack of evidence. The lack of evidence was denied to be allowed in.
Okay, all right, I
And again,
understand.
it's very important to get down to the understanding that if a legal guardian, parent, or advocate can't get the clinical record and the contract that we're questioning into record, then what were we doing there? Why were we spending taxpayer dollars to go through this if we weren't going to get a resolution?
Yes, I understand that piece of it for sure. I do also understand the concept that, not the clinical record side, because I get that 100%. I know that the contract exists between the designated agency and the shared living provider, and is probably a question about whether or not the Human Services Board has jurisdiction about that contractual relationship. I'm not a lawyer, but I can see why that could have been an issue. However, that wasn't the rationale that you were given for the denial of your appeal. It's helpful information. Go ahead, Representative McFawn.
The family were told they need to go to the Human Services Board.
By the designated agency? Mm-hmm.
When they went through that hearing process for years, back and forth. And then they were told, your next step is to go to the Human Services Board. So we did.
Yeah. I mean, that is the sort of line of process, when it starts at the agency level, moves to the department, as we heard yesterday, and then, or whatever day it was, and then moves to the Human Services Board. It is an individual or their legal guardian's right to make a decision about whether they go there or not. It also could have been helpful for somebody along the way to say that there might be a jurisdiction issue. But that still gives them the right to do that. Yeah, I get that. Yeah. Any other questions? We really, really appreciate you sharing your story, especially realizing how traumatic this whole process was for you. And we especially appreciate the fact that you shared it with us here as we try to improve on the process for Vermonters who haven't yet gone through this process. So thank you very much.
Thanks for hearing us.
Thank you for listening.
Thank you.
Take care.
Bye.
Okay.
Madam Chair, if I
Yes.
could make a statement.
Yes, of course you can.
Not only did the family feel this, I personally felt I was affected by this. And I was with this family all the way through their process. And I felt, I would go home at night and say, how the hell can they be treated like that? So I just share that with the committee.
I appreciate that. Anybody have any questions for Representative McFawn? He was part of this process, so.
They're constituents of mine.
Yes, I realize that. Okay, alrighty, thank you all, appreciate this. We are going to adjourn a little bit early for lunch. And as I said, we're gonna be looking at markup of this bill next week. And I'm hoping that the Department of Disabilities, Aging and Independent Living was listening to testimony today. We certainly let them know what was going to be happening. So thank you both for being here this morning. We really appreciate it.
How can I see a copy of this recording?
Oh, so it's.
Our committee assistant, Lori Morris, will send you a copy of the recording. She'll send you the link to it.
I appreciate that.
Thank you.
Will I need a passcode or something?
No, it's on YouTube.
Okay.
Thank you very much. Thank you
Okay,
for listening to us.
of course.
Thank you.
Alrighty, bye-bye. Okay, committee members, just so you know, whoops, I just closed my computer. What we're doing this afternoon?
36.
After floor, that's what I thought. Okay. So after floor this afternoon, which will be very short, we're going to take up S36. And we'll be hearing from the Agency of Human Services about that. So